5 seconds to go. Start. He submits that the central government is bound by such representation. Stop. It is submitted that the industrial units like that of the appellants, relying on the promise made by the central government, have altered their position to their detriment, and as such, the central government is now stopped from resealing from the representation made by it to the appellants. Stop. Para. Shri Ganesh submits that the figure of refund only to the extent of 58% has been achieved in an arbitrary and irrational manner. Stop. He submits that the union has purportedly done so under the umbrella of the report of the Finance Commission. Stop. He contends that, even under the earlier regime of excise tax and all other levies collected by the central government, the states were entitled to their share therein. Stop. It is stated that the share of the central government and the state government in the said regime has always been there, and it is not as if it has come for the first time after the GST regime started. Stop. Learned Senior Counsel submits that under the old regime, though the central government was sharing with the states a certain percentage of entire taxes collected by it, still 100% exemption from the payment of duty was being granted to the entities like the appellants herein. Stop. It is submitted that there is no reason as to why the same should not have been continued under the new regime. Stop. Para. Shri Ganesh further submits that the policy as is reflected in the said OM of 2003 would stand on a higher pedestal than the statutory provision or a notification under a statute, and the union would be bound to adhere to the same. Stop. He submitted that even in January 2003, when the exemption notifications were issued, the same sharing pattern was in existence between the states and the central government. Stop. Para. Shri Ganesh further submits that under Section 11 of the CGST Act, the government has the power to grant exemption from tax, and there is no reason as to why the union government should not have exercised such a power in the peculiar facts and circumstances of the case. Stop. Para. Learned Senior Counsel, therefore, submits that the view taken by the Delhi High Court is not sustainable in law. Stop. He submits that the appeals deserve to be allowed and a direction be issued to the central government to provide 100% reimbursement of CGST for the remainder of the period. Stop. Para. He also relied on judgments of various high courts. Stop. However, we do not find it necessary to refer to them in as much as the law on the issue is very well crystallized in various judgments of this court. Stop. Para. Shri V. Sridharan, Learned Senior Counsel, also submitted that the central government had come out with a policy of promoting industrial growth and employment in the backward areas. Stop. He submits that even after the GST regime, it should have continued the said policy. Stop. He submits that, if the central government has brought down the benefit from 100% to 58%, then it should increase the period of benefit to ensure that the promise made in 2003 industrial policy is given effect to in reality. Stop.